Good morning, everyone. Thanks for joining this workshop on SBIR data rights. I see that people are still trickling in, so I'll give everyone a few minutes to hop over and get settled, and then we'll begin. Well, I will let anyone else joining late just join, but thank you all for being here. As I said previously, this is going to be our workshop on SBIR data rights, protecting intellectual property during all phases of your SBIR STTR contract, grant and contract. It is being presented by Sandy DeCossola and Jim Vickers from Summit. And before we begin, I would like to just take the opportunity to let you guys all know about some upcoming events that the ACA will be hosting as part of our series on the SBIR program. I'm going to pop a link in the chat on just some upcoming events that you guys will be able to register for. Let me see, where's the chat? Everyone. So as I said, this is the link to join upcoming events. Just for you guys' information, on May 4th, we'll be having a workshop on university partnerships and consultants under the STTR and SBIR program that will also be presented on by Sandy and Jim. And I also want to take one quick moment to also say, for anyone who's interested in applying for the SBIR program, the ACA has a $3,000 microgrant program that can go towards costs for hiring a grant writer and getting through your application to write a successful proposal for the SBIR program. So anyone that is interested in attaining SBIR funding, I would encourage you to check out the second link. That is the link to the application where you can kind of let us know what your SBIR idea is and what funding agency you want to apply to, and flesh that out. And then we'll be awarding 6 of those $3,000 grants to eligible SBIR companies after April. That application closes at the end of April. So if you're interested, I would highly recommend and encourage you all to apply for that because it's just a great way to get some funds, for your program. Like I said, hire a grant writer, join an incubator, learn, hire a consultant, anything to help you kind of get across the finish line, secure that SBIR phase 1 funding. So that's all I have on my end. I'm going to toss it over to Sandy and Jim. Before I do that, I would just love to introduce them to you and give a little bios for each of them. Sandy is the owner of Summit Contract Management, LLC in Tucson. The company is dedicated to helping inventors, entrepreneurs, and small businesses work with federal government agencies. Summit provides step-by-step guidance in government procurement, from the management of new intellectual property to contract closeout. Ms. DeCossola has helped large and small businesses succeed at each stage of the procurement lifecycle for over 35 years. She spent her first 15 years working in contract management for large defense contractors such as Williams International and Northrop Corporation Defense Systems Division. Since 1997, she has primarily worked with inventors, entrepreneurs, and small businesses. The Summit team specializes in assisting companies under the Small Business Innovative Research, SBIR, and Small Business Technology Transfer, STTR programs. Summit was an approved AZ Fast Grant provider via the Arizona Department of Commerce program. Ms. DeCossola also assists small business pursue GSA schedule contracts and a variety of contracting grant opportunities with city, county, state, and local federal agencies. The Summit team also provides contract and grant management services, including setting up government accounting systems to businesses across the country on a needed basis. Many Summit customers are SBIR and STTR contract and grant awardees. Ms. DeCossola holds a Bachelor of Science degree with a major in finance from Roosevelt University, Chicago, Illinois, and she is a past president of the National Contract Management Association. We also have Jim Vickers here. Jim is currently an executive consultant for Summit, and he has over 40 years experience in acquisitions and contracting, including major acquisitions, contract claims, international contracting, contracting processes, and value engineering. He is retired from Raytheon Missile Systems, where he served as Director of Contracts for Advanced Security and Directed Energy System product lines for Raytheon Missile Systems in Tucson. Prior to this position, he led the export licensing group and spent 13 years on the AMR AAM program. He led RMS value engineering efforts as well as contract compliance efforts, including new initiatives. He's a frequent speaker on value engineering and shared savings and government contracting regulation initiatives and other acquisition issues. Jim is a retired Naval Reserve commander, and he holds an MBA from California State University, a JD from Laverne University, and is a member of the California State Bar. He's also completed the course requirements for a doctorate in management science at the Florida Institute of Technology. He is a National Contracts Manager Association Fellow and a Certified Professional Contracts Manager, and is Treasurer and Director of the Larry Miles Value Foundation. And with that, I would love to hand it over to both Sandy and Jim. So take it away, guys. Thank you.
Okay, thank you for joining Jim and I, and we'll get started. I always like to start with, let's see if it'll work, with talking very quickly about this life cycle that you would be entering if you want to pursue an SBIR or STTR grant or contract. So we're going to talk about intellectual property in the context of this life cycle. So you come hopefully with some kind of innovation. You need to look for a solicitation, one from the 11 agencies that participate in the SBIR program. You'll prepare and submit a proposal. There'll be requirements for marking your proposal. You'll find yourself in pre-award, where you'll be asked questions and looking at, in this presentation, Jim will be talking about the various types of data rights. You receive your award. It has a lot of terms and conditions, and we'll touch on a few of them. You perform and deliver. You submit reports or prototype possibly. There's going to be marking requirements, and then you close out, and there'll be reporting requirements on your IP at closeout. And that is the entire life cycle. So our agenda for today is we're going to talk, Jim is going to start with talking about protecting your innovation right now before you've even considered submitting a proposal. Then he's going to hand it to me to talk about marking the proposal. I'll hand it back to Jim. He's going to talk about the different types of data rights, and then back to me about the clauses and some of our recommendations for managing your intellectual property. So with that said, I'm going to hand it to Jim about starting right now with protecting your innovation.
Here's the definition of intellectual property, which is basically any creative work you do. And common ways of protecting that are through patents, trademarks, copyrights, and trade secrets. The latter is probably the most widely used and easiest to use and often the most effective. Okay, next slide, please. Some of the ways you protect it is documented through your lab notebooks. If you invent something, you have someone sign it and witness it and keep that. Your accounting records. Later on, it will show that in order to own something, you have to do it at private expense. So you want to keep track of the costs that you do it for. You would have an IRD account or some way of showing this effort that you invented it was not chargeable to any contract you were working on. It'd be a job number or whatnot. Then once you have it, if you give it to anybody else, you have to do covered by a non-disclosure agreement from the start. Next, please. These are the way you protect proprietary information. There are two kinds. There's a one-way where one party gives the data to the other party, and there's a two-way where both parties exchange information. You want to be careful here because some of our clients have actually taken a one-way, which is one way to them, and their data wasn't protected because the only thing was protected was the other party's data. You don't receive or disclose any proprietary information until the non-disclosure agreement is executed. Sometimes these are called PINDAs, Proprietary Information Non-Disclosure Agreement, or PIAs, depending upon the part of the country. It turns out that the word NDA got a bad rap because of some of the celebrity NDAs like Donald Trump and Stormy Daniels or things like that. So some places prefer to use the word PI, Private Information Non-Disclosure Agreement. Next, please. So there's what we call an industry standard NDA with some common elements. A few years back, I reviewed 1,000 of these and printed this paper on them. And these are some of the things that come up and they should be in all of them. First is the scope of it. You want to limit it to what you're doing. And you only disclose data within that scope. So if it may be marketing, you just give marketing data. If it's actually design or develop something, then you really narrow down the part that you talked about designing and developing. Another common term is the term of the project or how long it's good for. You want to make sure it's long enough to exchange the data, and the period of protection is long enough to protect what you have. Another common term you want to be careful for is, or not a lack of term, is that there's no requirement in the agreement to disclose information. This is just a voluntary between the two of you. Any requirement should be somewhere else, a teaming agreement or a contract. The exclusions, which are in almost all agreements, are things that are in the public domain, disclosed to others without restriction, were already known by the receiving party, or independently developed by the receiving party without knowledge what was disclosed to them. Next, please. There are other standards clauses you see in some of these agreements, like ITAR export control requirements that say you won't disclose it outside the country, no promises of future work. A lot of companies put that in, which is okay. Independent contractors, another common term that says both you are independent contractors, no relationship between them, and a requirement to return the data at the end of the agreement. If there's anything besides these, it could be a problem. It's more than an NDA, or like a commitment with others. That's one of the reasons why I got to looking at these, because some people were adding other terms that don't belong to them. One other term you want to watch out for is no reverse engineering. Some agreements have this clause. And this can be a problem unless there's restrictions to it, because you can be in a situation where you agree to not reverse engineer, and the stuff becomes publicly available, and everybody else in the world can reverse engineer, do things with it, but you. So you have to, in those cases, you have to make sure you have some restrictions if there is such a clause. But then it goes both ways too. So next, please. Next slide.
Sorry, it wasn't progressing. There we go.
There's also a thing called a material transfer agreement, particularly in science. And this is when you're passing on a sample of something, usually it's in agriculture, where you give a plant or things like that, or some material you want them to test. It's just like an NDA, same terms as above, except you have to limit the amount what's being transferred and make sure it's returned to you when you're through with it, all unused. And you limit the use of it, just like you would on the scope of the NDA. Next, please. Am I doing this, Sandy?
Yeah. Mm-hmm.
These are the laws associated with the NDA. Uniform Patent Law by Doyle. This is the law act that came in that gives universities and inventors the rights to what they invent. Even though it's paid for by government money, the actual inventor gets a cut at what's been invented. Small Business Patent Law, same thing, preference. Edison interagencies. This is where you store data. Sandy will talk about it more later. The data rights clause in the FAR, part 27. This really lets out the governance and rights between the data that's developed under the contract. Additional SBIR provisions for civilian agencies and for military agencies. These are the clauses that give special rights to SBIRs. And then the FAR clauses, DFARs, the two listed here, which are the ones that talk about the marking of data and the rights of data. We list these here so you can look them up if you need them and keep this as a reference. Next, please.
Okay, and on that note, I apologize, I forgot to let everyone know that the ACA will be sending you these slides if you would like them. because we do have a lot of detail and references that you might want to hang on to for later. And the other quick comment is, please do put any questions you might have in the chat box. We'd love to make this interactive and answer your questions as we go along, rather than waiting. We will have a Q&A at the end as well, but feel free, Kyle and I will try and keep an eye on the chat box. So now you're at the point where you've made the decision as a company that you would like to submit an SBIR or STTR proposal. And by the way, I may sometimes just say SBIR, but these terms are interchangeable, SBIR and STTR in most cases. So very critical to know that each solicitation will have unique requirements for marking your proposal proprietary information. So what I show you on these slides, you don't want to use verbatim. You always want to go back to the solicitation because each agency has a slightly different twist on it. So here they are saying, if you include the information and you don't want it to disclose to the public. So in this case, I took the definition from a recent DoD Department of Defense solicitation, and which, by the way, I'm giving you two examples today, just from the Department of Defense, who is the largest funder of the SBIR, STTR programs, and then the National Institutes of Health, who is the second largest funder. But it's quite similar amongst all the other agencies. But like I said, here's the definition of the Department of Defense, how they consider proprietary information. So typically when you're writing your technical volume, you may want to include, although we don't recommend it, trade secret information. You'll have some budget information that might have proprietary company rates, or depending on the topic, there could be something that could affect national security. So you definitely do want to mark that. So here's an example from the Department of Defense where they will give you a legend that will go on the first page of your technical volume. And then you will tell them in the proposal which page numbers this legend will apply. I will tell you there is a trend that I see within the DoD that they really try to discourage you from putting, and Jim will talk about this in a minute, limited or restricted rights information in your proposals, but sometimes companies feel they can't avoid it in order to be competitive and convey the idea about their invention. Important to make sure that you not only put the legend on the first page, but that you continue in the footer on the other pages as permitted by the solicitation. And here are NIH's instructions. They're telling you that, here's the legend, and they go on to tell you different ways you can mark paragraphs or pages to refer back to the legend. So many of you are probably familiar, if you've already registered your company in the System for Award Management, with this table that is in the clauses in the registration, and it's called the Identification and Assertion of Restriction on the Government's Use. And this is what Jim is going to go over, are the different types of asserted rights that your innovations might fall under. I just have a comment regarding the SAM. Typically, I recommend to companies to mark the box that you will provide on a case-by-case basis. And so this table is normally, very relevant if you're submitting a DoD proposal. You'll be asked to put the table in the volume 5 other supporting documentation section. But the key here is, this is where you're going to raise your hand and say, hey, government, I'm going to use in my proposal project either technical data or computer software that I developed at private expense with my own money, and I'm going to allow the use of it in these limited ways. And this is also an opportunity. Let's say you developed some SBIR, some technology that has SBIR data rights, let's say under an NSF grant, and you want to use it under a DoD contract. So you'll have the opportunity to identify that. And again, Jim will be going over these rights, but just wanted to make sure that you're not alarmed when you see this, when you're submitting your proposal. Now you'll have some information about how to complete the table. So I'm going to hand it back to Jim, and he's going to discuss the main kind of rights that you'll typically see.
Okay. Unlimited rights, we'll discuss. That's what happens if you don't have any way to protect it or own it. Restricted rights are limiting what the government can do with respect to computer software. Same thing as limited rights. Difference is one's for software, one's for hardware. The other one is specifically negotiated license rights. These are ones that give the government some rights, or with respect to restricted rights and limited rights, a more limited license. For example, under restricted rights or limited rights, they can use the data, but you might want to say they can only use it on such program. That'd be a specifically negotiated license. Government purpose rights, we'll talk through a little further on. SBIR rights and prior government rights. Next, please. Now, limited rights is developed at government expense. Anything the government pays money for that you don't have an otherwise right to it. It's unlimited. The government can use it any way it wants or have someone else use it. Unlimited rights also be used outside the United States government, anywhere. There's no restrictions. If you do not assert any rights or mark that this is default position to take unlimited rights to what you have. Now, that doesn't mean you don't own it, even though the government pays for it, but they just have unlimited rights to use it any way they want to. And there's some value in you owning it because they don't necessarily give out what they paid for. So even though they own it, they have every right to it. You still own it. And you can use it in other programs unless there's some other restriction. Next, please. Limited rights is for technical data. It's developed at your own expense. Actually, it could be for hardware too, but exclusively of private expense. Uses within the government, but not for manufacture. This is what I mentioned for special license. If they want to use it beyond totally in the government, or if you want to restrict whether they use it with the government, it'd be special license. And permitted uses outside the government just for emergency repairs, overhaul, and certain service maintenance contracts. All those people that would use it would be under a non-disclosure agreement with the government. Next, please. Restricted rights are the same as limited rights, except they apply to computer software. Again, it has to be developed exclusively at private expense. Government uses only one computer normally. Minimum backup copies available. And the same thing with uses outside the government for emergency repair, overhaul by service contractors that agree not to disclose things. Next. Next, please. Government purpose rights. This is kind of default. If you mix your funding with the government's funding, you end up with government purpose rights. These normally have a limited period of time, 5 years or 7 years, and limits the governments. The governments can use it without restriction, except they can't manufacture it, or actually can have others use it too. Permitted uses outside the government, only for government purposes, no commercial use. The problem with these rights here is if you're in the defense business and you're making a product, these don't do you much good because the government can use it or have others use it to manufacture, do whatever they want. So if you're Lockheed, you're building something, they could very easily, with unlimited rights, give it to Raytheon and have Raytheon build it. Of course, they couldn't use it to make something commercial, but for your purpose, it would be not much good. Next, please. SBIR data rights, both technical and software. This is unique protection accorded to SBIRs and STR firms. The government receives a license to use, not exclusive to use or have used the data, but such cannot be used in any other way, except for the rights they have. They must protect it from disclosure for a period of 20 years. So this goes beyond normal rights. There's a 20-year period. And it's sort of like a government purpose rights, but it goes on for 20 years and they will not disclose the information and protect it from disclosure. Next, please.
Okay, so I'm going to take it back and I'm going to talk to you about a clause, patent rights clause that I'm referring to here as the FAR 52-227-11. In grants, you'll have another form of it. Pretty much in every one of the 11 agencies will use this clause. And it's a very powerful and important clause because this is how you as the company can elect to retain rights to something you discover while using the government's money. So it's important to define, so I should say up front, I'm making the assumption when I talk about this clause that you're in a position where you've worked under your grant or contract and you have discovered something. And so what the clause, whoops, I went too far. Let me go back. I first need to talk about subject invention. So this assumption of you inventing something means that you have come upon a subject invention, which means you made this, discovered it, and put it to practice while working with the government funds. So as Jim was talking about, you can own this. However, the government will always have a right to use as the funder. So you will have to give them a license. So there is such a thing also as a non-subject invention, and the distinction here, it is like a subject invention, but this was invented and reduced to practice before or outside the government contract or grant. So this came before taking their money. So therefore, the government cannot require you to disclose it or use it during the contract. If you do choose to use it, the government will not be able to give it to others. So there are some very distinct timelines that the government includes in the clause. So one of your technical people has made a discovery and determined that they have an invention, and they've reported it to the person in the company in charge of intellectual property. From that point, you have 2 months to disclose the invention disclosure to the government. From that, and I'll talk about in a minute what belongs in that invention disclosure. There's some key elements. So once you disclose the invention to the government, the clause allows you 2 years to decide whether or not you want to elect to retain title to it, and 1 year to file a patent. So we're talking about essentially 3 years, and I'm not suggesting that you want to take that long, but often what I see happens is as many of you know who are familiar with the SBIR program, phase 1 is a feasibility study. Phase 2, you're moving further along. You may not even realize or decide that you want to elect to retain title and pursue a patent until phase 2. So this is giving you that time, except you must keep it held as a trade secret and not disclose. Otherwise, you know, all this bets are off. Once you do file that patent application, you'll receive notification from the government agency requesting a confirmatory license, because as I said, they'll allow you, even though they paid for it, to elect to own it. You do need to give them back a confirmatory license. You'll be responsible for paying all the patent fees and for continued reporting on that invention. So as I said, invention disclosures per the FAR clause must identify who the inventors are, identify the contractor or grant that the invention was discovered under, and convey a clear understanding of that subject invention, and identify any publications on sale or public use that may have already occurred. A lot of people don't realize that that clause also requires you as a company to have written employment agreements that have details about your technical employees' requirement to promptly disclose any subject inventions, and further to talk about the filing of patents. And you as the company are required to educate the employees on the importance of filing the inventions and following the regulations. The clause further discusses, and now I'm going to revert to the DFAR clause that Jim had mentioned, but there are very specific legends for each of the type of data rights that Jim just discussed. So it's highly, highly critical when you submit, which is quite typical in a phase 1, for you to at least have a deliverable of a final technical report. So you will want to mark with the proper legend. Usually in this case, it would be the SBIR legend, to make sure the government knows that you're raising your hand and saying, I developed this information while working under the government grant or contract. And the wonderful, unique thing about the SBIR program is that they're now giving you 20 years that the government agrees, if you mark it properly, not to disclose outside of the government. And one quick comment that many of you may not be aware of, however, patent costs, even though ironically the SBIR, STTR programs are commercialization programs, patent costs are typically not allowable under your grant or contract. And what that means is that you cannot use the funding that you received from the government to file your patents. So that's something to keep in mind. We were just discussing before this meeting that the Department of Energy has in their phase 2 solicitation some technical assistance money that you can use for patenting, but you must be very careful that you keep patent costs out as unallowable under your grants or contracts. And as Jim mentioned, there is the iEdison system. This was, I believe, developed by NSF, NIH, too many acronyms, the National Science Foundation, the National Institutes of Health use it. We're now seeing Air Force and other NASA, other agencies using. And this is a main portal where the government collects information about the inventions you discovered while using government money. And it's a pretty good portal of information about, as Jim noted, the Bayh-Dole Act that allowed for the SBIR and STTR programs. Let's see. I have a question. Can you use overhead for patent costs? Actually, no. What you can use for patent costs is typically the government allows around a 7% fee or profit on your grant or contract. And that's really the only money from the government that you can charge patent costs under. And another question, does that restriction on IP costs also apply to fee? And no, as I just said, that is the nice thing, that the fee, you can pay patent costs or go buy a boat, whatever you want to do with that money is yours as a company to do. Oops. So finally, we highly recommend, as you can see, this is a pretty detailed process that you'll find yourself in when you're working with intellectual property in your company. So we typically recommend that you designate a single person or a couple people who are your IP managers. As you can see, the dates for in the FAR 52-227-11, the 2 months, the 2 years, the 1 year, we usually recommend creating a log so you don't lose track of when you owe the government answers on the filing of patents, and just statusing your inventions and just keeping track of everything, and someone responsible for just double checking that your reports or your proposals are properly marked. So in summary, we can't stress enough how important it is to protect your intellectual property even before you're ready to go after your first SBIR or STTR contract or grant. You have to be very clear about raising your hand and asserting your rights, your limited or restricted rights right up front to let the government know. You'll see now, for those of you doing DoD proposals, they've added it right in the beginning of your proposal process. They'll ask you, are you going to assert rights? And a reminder that in volume 5, that's where you'll put the supporting documentation. Can't stress enough to keep track of this information. As you evolve, you may even want to have quarterly meetings to discuss. And because not everything you're going to discover while working under these contracts or grants are you going to want to spend money on to patent. And the government does have a right to know that if they paid for it. And if you decline to do that, then they are able to do so. And I'll ask you, Jim, have you ever seen a case where they've done that?
Yes, yeah, I have. Typically, in a larger company, they have a patent department, and that is an overhead. But they can only use that money for patents that the government has rights to, patents under contract, their own subject inventions, if you will, or non-subject inventions are outside of those costs, and they carefully monitor that you don't spend too much in that area. There's usually a pre-negotiated value for what you can spend on IP costs around on patents.
Okay.
Did I answer the question, or am I missing a little bit?
Yeah, I think so. So we have a question here. Can the SBIR funding be used to pay for FDA user fees? That's a very specific question. I want to say yes, but I would want to have an opportunity to research that to confirm. So I believe I have seen clients propose those kinds of costs, not really in a phase 2, or I mean in a phase 1, but I have seen them in a phase 2.
Yeah.
Okay. And then finally, we really can't stress enough that the SBIR and STTR programs are wonderful, amazing programs for small businesses. This is your chance to accept money, non-dilutive money that you can do your inventing and not have to share equity or anything like that, like you would with an investor. But I will tell you what we're seeing quite often when we meet clients who have already won, gone forward and won a grant or a contract, and who are working with, let's say, universities or other commercial partners in their industry. We're seeing license agreements and teaming agreements that really do not have favorable terms for small businesses who are just starting out with their first SBIR, STTR grant. And we just want to stress that there's a whole village out here, especially in Tucson and Phoenix, that are here to help you navigate this process, because there's nothing worse than when we see a license agreement that a company will meet them and they'll show us, and it has terms that we feel were almost bullying on the small business. And unfortunately, it's almost nearly impossible to go back and make changes, after you've already agreed to the terms. So we just can't stress enough to engage in help. The Arizona Commerce Authority is developing a whole database of providers that are here to help you with this process. And we really encourage you to take advantage of that. So with that said, we're open to any questions. And we're here to help, and we will send slides if anyone would like them.
Well, thanks, Sandy and Jim, and I'll let people have time to type their questions in the chat. And while that's happening, I have some questions for you as well, Sandy, if you would be willing to answer my questions.
Sure.
So I guess my first question is, can an agency, can a small business negotiate the data rights with a funding agency, or is it set in stone completely from the beginning?
I'll let Jim answer that question.
You can negotiate it, but some of these things are required by law. If the government is paying for something, it has to get the rights for the money it spends. So you can own up to where you get the government's money. You can own anything done outside the government's money, but they have to get the rights to what they pay for. And that's the same thing with state governments for the most part.
Cool. Awesome. Thank you. It looks like we did get one question in the chat. Are you guys hourly or contract based?
Our services, we typically charge hourly.
Cool. Thank you. So kind of going off what you said, Jim, so with the data rights agreement, is it my understanding, if you could confirm, the awardee owns and has full rights to the data developed, but they are in a IP sharing agreement with the agency, but they still technically, the awardee technically is the owner of those rights. Is that correct?
That's correct. The awardee will own the data even if the government pays for it. The government, in return for paying for it, gets unlimited rights or whatever other rights are negotiated in the contract. In some of these contracts, I have seen contracts where the government will agree that they will give you government purpose rights for everything, even what they fund. Not recognizing, of course, the government purpose rights prevents them from only uses for government use, not to go and have somebody else make it. You still retain the commercial rights, and companies have done that, and particularly if they have a strong bargaining position.
Cool. Could you elaborate specifically on what does rights to data rights mean?
Rights to data rights. Well, maybe we should start from what we're talking about. You enter a contract, you walk in with certain rights that you had before, and you retain those rights. What you develop in the contract typically belongs to the government. You may be able to negotiate something that says an advanced agreement, if you will, that says how you will share the rights and what's developed underneath the contract. That'd be almost like a special license, which would probably involve you bringing in some of your outside rights and the government taking some restrictions on stuff that they would normally get unlimited rights to.
Gotcha. Thank you. So after that agreement is entered into, how long are those data rights protected?
Well, typically on we're talking about general purpose rights now. You're typically like a 5 to 7 year period, but you could do longer than that. After that, then the government will change up to unlimited rights.
Mm-hmm.
And in that sense, you would want to have revert back to you whatever rights you had that were outside of this.
Mm-hmm.
And I'll interrupt for a second. When we're talking about SBIR data rights, it was just recently that the government made the change from with DoD contracts. It was 5-year data rights that the government would not disclose inventions discovered while working under the grant or contract to the public. And with the granting agencies, it was 4 years. So they bumped it up essentially to match the life of a patent. So you now have 20 years if you mark everything correctly, that the government agrees to not disclose information outside of the government.
Mm-hmm. And with that agreement is in effect, what could you elaborate more on the specific rights that the government has to the data?
Go ahead.
Go ahead, Sandy, if you want to answer.
No, you can. Go ahead.
The government generally has government purpose rights to the data. What they're doing under the SBIR rights, though, is they're saying that we will not disclose this to other people outside the government for this 20-year period. So if they wanted to take that data and make something themselves with it, they could.
Gotcha. Thank you. What should someone do if they think someone has disclosed their data or their invention?
Well, I always recommend, you mean someone within the government? You have to first look in your own backyard, so to speak, and make sure that you did properly mark everything. Because unfortunately, we hear a lot of horror stories and people will say, oh, I don't recommend using the SBIR programs because the government is going to steal your idea. You'll hear things like that. But really, that's not what's happening. Most often is what's happening is the government contractor neglected to mark the rights, mark the information according to the various requirements. And so the person on the receiving end at the government has no idea that it's coming with those rights. And so really, how can we expect them to treat it that way if the contractor didn't mark it properly? But if the company does feel they marked it properly and the government has disclosed it, then, and Jim, correct me if I'm wrong, but I believe the first place you would want to start, at least on a DoD contract, would be to put that in writing to your contracting officer and see how they respond with that.
Well, that's quite true. It's mixed depending upon whom you're dealing with and what they'll do. But clearly, if the government discloses something that is proprietary, that's a crime. So they're very defensive about that. It's 18 USC 1000, I believe, for a government employee to disclose proprietary information outside the government. But I don't think that's where most of the problems are. Most of the problems are with someone else using it, is a former employee taking the data with them. Then that's definitely a problem. And we were a little weak on our slide on employee agreements we took what the government asked you to do, but we should go beyond that. And in your employee agreement, you should have terms that say they won't do that. They'll tell you where they work and things like that. So you have a right against the employee and his company that uses it.
Mm-hmm. Cool. And I think that kind of answers my next question, but I was going to ask, how do you discuss your innovation with potential partners and customers without jeopardizing or exposing those data rights?
Yeah, with a non-disclosure agreement, of course. And often what they'll do is, that's why it's kind of important you want to watch this, because some companies will be very careful on a non-disclosure agreement. They want to make sure that they don't have anything in that area that you're disclosing to them before they take your data.
Mm-hmm. Awesome. Well, those were all the questions I had. I'll give a few more seconds just if everyone has any last minute questions. But other than that, I appreciate you guys for taking the time to go over this data rights workshop. And just as a reminder, Jim and Sandy will also be doing a follow-up workshop on May 4th on partnering with universities and contractors and the intricacies of that. And the link to that to sign up is in that link that I shared earlier. And let me just pop it in the chat one more time for you guys.
Yeah, Kyle, we really didn't take the time to go into how these various clauses and data rights are flowed down to university or other company partners. And we'll definitely go into that more deeply in May. But just want to highlight the fact that, as Jim said, a lot of these clauses and requirements are mandatory. And so you as the prime grant or prime contract holder will be required on the mandatory clauses to flow these same rights down to your subcontractors and subawardees, whether they be a university, a national lab, or another contractor. And like I said, we'll go in more depth in that in the May webinar.
Cool. Awesome. Thank you. I appreciate it. And just as a reminder for everyone else, we'll be sending out these slides after the presentation shortly. If you have any questions, you can always reach out to Jill or myself or Sandy. She has her contact information listed there. And once again, I just want to thank everyone for attending, and I hope to see you at our next workshop. But if no one has any other questions, once again, thanks for attending, and I hope you guys have a great day.
Thank you.
Thank you, everyone.
Bye-bye.
Thank you.